Good evening, ladies and gentlemen. Welcome to our 11th floor. I'm Michael Haw. I happen to be the Dean of the faculty here. We're very pleased to welcome all of you here to this Hochelaga lecture. A special thanks to the Chief Justice Diana Bryant of the Family Court of Australia. I won't be saying much about the Chief Justice because there's someone else who will do that here. So what I'd like to do now is to introduce the chair of today's lecture. The chair of today's lecture is someone whom I've known since my second year in law school. Professor Leong Wai Kam was my teacher. Doesn't look it, right? I mean, I look older, but anyway, I don't know what her secret is, but she actually was my teacher in the second year in law school, and it was family law. I still remember very clearly the lectures that she gave. Matrimonial property, customary marriages, voidable, whatever. And although I have had nothing to do with family law since then. So you can see the effect that she has had on me. So without further ado, I shall invite Professor Leong Wai Kam, who is a visiting professor in Hong Kong University for a few weeks, to introduce our speaker today. Thank you.
Thank you, Michael, for such a warm introduction. Good evening, ladies and gentlemen. As chair this evening, it is my pleasure to welcome all of you to the Center for Comparative and Public Law at the Faculty of Law at the University of Hong Kong. The center is hosting the 2015 series of Hochelaga lectures. And the 2015 lectures revolve on this theme: the judiciary's role in safeguarding the well-being of the child. Tonight's Hochelaga's lecture is the third in this series. As chairperson, I have the great honor of introducing our most distinguished speaker this evening, and she is the Honorable Diana Bryant, AO, who is the Chief Justice of the Family Court of Australia. Now, as I look around this room, I think that what I'm about to say may be known to many of you in the room, but I shall have to discharge my responsibility of giving our most distinguished speaker the proper introduction she deserves. The Honorable Chief Justice Diana Bryant, AO, was appointed Chief Justice of the Family Court of Australia in the year 2004. Prior to this appointment, she was the Chief Federal Magistrate of the Federal Magistrates Court of Australia from the years 2000 to 2004, where she guided the emergence and growth of that court as its inaugural Chief Federal Magistrate. She is also one of the 2 Hague Network judges for Australia, and as many of you know, is presently chairing a working group for the Hague Permanent Bureau in relation to the Child Abduction Convention. She is also co-chair of the Association of International Family Judges. Chief Justice Bryant received a centenary medal in 2001 for her role in the establishment of the Federal Magistrates Court. In February 2009, Chief Justice Bryant was appointed Patron of the Australian Women Lawyers in recognition of her support for women lawyers and her efforts to promote equality of opportunity for women in the legal community, and was made an Officer of the Order of Australia in 2011 for her distinguished service to the Judiciary. Chief Justice Bryant holds Bachelor of Laws and Master of Laws degrees and was admitted to the Victorian Bar in 1970. From 1977 to 1990, she was a partner in the firm of Phillips Fox in Perth, where she practiced as a solicitor and counsel, specializing in family law and de facto property disputes, particularly at the appellate level. She was appointed a Queen's Counsel in 1997 and was a founding member of Chancery Chambers in Melbourne. Chief Justice Bryant has presided in a number of significant family law cases in Australia, including G&G, a law firm, and McMurphy, which is reported in 2012 Family Court of Australia Full Court at page 134, which concerns a law firm's unrelenting tactical approach towards a client. Recent cases include, and I'm only going to give a very short list. First, Child Support Registrar and Aham and another, reported at 2014 Family Court of Australia Full Court at page 105, which is on the scope of the jurisdiction and power of the Social Security Appeals Tribunal in relation to review determinations made by the Child Support Registrar. Also, Fields and Smith, reported at 2015 Family Court of Australia Full Court at page 57, which is an assessment of the parties' respective contributions and their subsequent percentage entitlement to property. And last but not least, Martin and Newton, reported at 2011 Family Court of Australia Full Court at page 233, on the probability of the party carrying out their stated intention of using the funds in accordance with their moral obligation. The Chief Justice has decided to entitle her Hochelaga lecture this evening as Challenges in the Development of International Family Law, Reflections by the Chief Justice of the Family Court of Australia. Chief Justice Bryant, the podium is all yours.
Thank you very much. Professor Waikum, Dean Michael Hoare, Professor Anselmo Reyes, distinguished guests, ladies and gentlemen. I am very honoured to have been asked to give this third in the series of Hochelaga lectures, and I'm pleased to say that my colleague, Justice Victoria Bennett, who is here with us tonight, gave the first, I think, of the Hochelaga lectures this year in this series. When I was first invited to give the lecture, I must say that I was intrigued by the name, as no doubt most people are. What I did find out about it was that it has a very prestigious pedigree indeed, and many prestigious, far more than I, speakers have given this lecture in the past, including Chief Justice Beverly McLaughlin of Canada. It carries with it a deal of intrigue of its own. It is a lecture which was funded anonymously by a donor, I gather, in tribute to his father, who, as I can best understand it, had some interest in the Hochelaga Indians, who were Native Americans from Canada in the place where Montreal is now built. So an intriguing background indeed. I'm afraid that I was overly ambitious when I wrote the abstract for this paper. My enthusiasm for the topic got the better of me, and I failed to realise how long it would take to address the issues raised in anything more than superficial detail. Unfortunately, this means I must skim through much of what was promised, but you can rest assured that my paper, which I understand will ultimately be published, contains a more thorough treatment. In the interest of time, then, I'm going to assume that most of you know what I'm here to discuss, and rather than foreshadowing the substance of the lecture, I'll go right into it. I'll just preface by indicating that much of the lecture concerns, either directly or peripherally, what are collectively known as the Hague Children's Conventions. the Convention of the 25th of October 1980 on the civil aspects of international child abduction, called colloquially the Abduction Convention, the Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption, the Inter-Country Adoption Convention, the Convention of the 19th of October 1996 on, I won't give you the long title, but it's called the Protection Convention, and the Convention of 23rd November 2007 on the International Recovery of Child Support and Other Forms of Family Maintenance, the Child Support Convention. As has been frequently acknowledged, the intersecting forces of globalisation have created a situation in which human mobility has reached unprecedented levels. Global trade and markets, communication, travel and migration have changed how families are formed, maintained, and unfortunately how they break down. Naturally, this has meant that the practice of family law has in turn become globalised. Familial disputes occurring across international borders present special difficulties, such as the necessity of dealing with an unfamiliar legal system, language and cultural barriers, and lack of friends and family to act as a broader support structure. As such disputes proliferated in the second half of the 20th century, effective tools to regulate them became necessary. The task of creating those tools fell to the Hague Conference on Private International Law, the Hague Conference. Since 1983, the Hague Conference has provided, since 1893, so the Hague Conference has provided a forum through which different legal traditions can engage in the work of responding to global needs in the civil and commercial spheres. In 1955, the Hague Conference became a permanent intergovernmental organisation. At that time, the Hague Conference's membership was made up of 15 Western European states and Japan. Today, there are 80 members, comprised of 79 states and the EU. The Hague Conference meets in principle every 4 years in plenary session to negotiate and adopt conventions and to decide upon future work. The preparation of conventions themselves is undertaken by special commissions or working groups. Once completed, each treaty is adopted by the Hague Conference at a diplomatic session and then opened for signature and ratification or accession. The conference maintains a detailed drafting history for each convention and prepares an explanatory report to aid in interpretation and application of the convention. It also publishes practical handbooks and guides to good practice. Indeed, as you will hear a bit later, I'm currently chairing a working group tasked with developing a guide to good practice on the grave risk defence in the Abduction Convention. The Secretariat of the Hague Conference is called the Permanent Bureau, the main task of which is the preparation and organisation of the plenary sessions and special commissions. The Hague Conference's traditional purpose was to work towards the progressive unification of the rules of private international law, including commercial law, civil procedure, and family and children's law. More recently, the Hague Conference has focused upon judicial and administrative cooperation in these areas, facilitating international judicial and administrative cooperation by taking on new roles, implementing and monitoring the conventions, and providing education and assistance for participants. This has given the Hague Children's Conventions a special character. Whilst they emerged from the private international law landscape, they have, to quote Professor Anne Eston, they have blossomed into something new, a hybrid species with a strong public law character and a unique structure. The success of the Hague Children's Conventions has seen the proliferation of international family law jurisprudence. The Hague Conference is established for case law on the oldest and most jurisprudentially prolific of the Hague Children's Conventions, the Abduction Convention, a searchable and continuously updated database called INCADAT, comprising summaries of decisions, links to the full texts of judgments, and compendia of legal analysis. This is another example of the Hague Conference's innovative approach to facilitating collaboration between contracting states. Before I move to a brief discussion of each of the Hague Children's Conventions, I must mention what Adair Dyer, former Secretary-General of the Hague Conference, has rightly called the essential backdrop for international children's law, and that is, of course, the United Nations Convention on the Rights of the Child. Since its entry into force in 1990, the Convention on the Rights of the Child has, quote, sustained and reinforced the Hague Conference's project of developing a transnational children's law by articulating general principles without detailing specific mechanisms to accomplish its goals. It's become the most rapidly and widely ratified international human rights treaty in history. Today, the majority of the world's states have ratified the Convention on the Rights of the Child. Australia ratified the Convention in December 1990. While the Convention hasn't been incorporated directly into Australian law, one of the objects of the parenting provisions in the Family Law Act 1975 is to, quote, give effect to the Convention on the Rights of the Child. Thus, the Convention doesn't override any specific provisions in our domestic law, rather it's an aid to interpretation and can be used to resolve ambiguities in domestic legislation. The Convention on the Rights of the Child makes clear reference to the Abduction Convention, which preceded it, and there are also clear links between the Convention's provision and the Hague Children's Convention, which followed its adoption. I want to now just turn to the Hague Children's Conventions. First of all, the Abduction Convention. This convention grew out of the increasing problem which emerged in the second half of the 20th century of parental relationships breaking down in circumstances where there were citizens of different countries, followed by the unilateral decision by one of the parents to return to their country of origin, usually, with their child in tow. The Abduction Convention therefore focuses on restoring the status quo by securing the prompt return of a child who's been wrongfully removed from his or her place of habitual residence. The intention is to deprive the taking parent of any jurisdictional advantage and prevent forum shopping. All contracting states recognise that a child's best interests are served by their prompt return to their place of habitual residence. The underlying idea is that the authorities in the child's place of habitual residence are most appropriately placed to look into the merits of a parenting dispute and decide upon issues of custody and access. Thus, the Abduction Convention is particularly aimed at discouraging a court in the country to which the child is taken from accepting jurisdiction to determine a custody dispute on its merits. This means that for judges, application of the Abduction Convention is somewhat counterintuitive, in that we are required not to apply our country's laws or to enter into a full inquiry about what is in the best interests of the child. Rather, we must apply the Abduction Convention, and if the requirements are met, return the child to the country of habitual residence. Article 11 of the Convention on the Rights of the Child, which obliges states parties to take measures to combat the illicit transfer and non-return of children abroad, reinforces the Abduction Convention. To this end, states parties are encouraged to promote the conclusion of bilateral or multilateral agreements or accession to existing agreements. Generally speaking, a removal or retention is wrongful if it is one that is in breach of rights of custody of the left-behind parent under the law of the state in which the child was habitually resident. The concept of habitual residence is not defined in the Abduction Convention or indeed in any of the other Hague Conventions in which it appears. The Hague Conference considers the question of habitual residence to be one of pure fact, and the decision not to include a definition was a deliberate one. Where a child has been wrongfully removed from or retained outside of their country of habitual residence, the child must be returned unless the respondent can show that more than 1 year has elapsed since the child's removal and the child is settled in his or her new environment, or an exception to return can be made out. The exceptions are contained in Article 13 and include circumstances where the person applying for return subsequently consented to or acquiesced in the child's removal or retention, where there's a grave risk that the return of the child would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation, and where the child objects to return and has obtained an age and degree of maturity at which it's appropriate to take the child's views into account. One of the emerging issues for the continued success of the Abduction Convention is the treatment of domestic violence in the context of the grave risk defence in Article 13b. Domestic violence has emerged as an issue because of the demographic of abducting parents, which has, contrary to what the drafters of the Convention anticipated, turned out not to be abducting fathers, but rather mothers wishing to return to their countries of initial residence, sometimes to flee domestic violence. There are many new signatories to the Convention, and it's easy to anticipate significant differences in instruments and legislation between at least some of the 93 contracting states where issues of domestic violence are concerned. Following Hague Conference discussions in 2011 and 12, broad support emerged for the establishment of a working group comprised of judges, central authorities and interdisciplinary experts to develop a guide to good practice on the interpretation and application of Article 13b. As mentioned, I chair that working group and some of the members of it are here tonight. The second convention is the Inter-Country Adoption Convention. This was preceded by the 1965 Hague Convention on jurisdiction, applicable law and recognition of decrees relating to adoption. However, by 1988 it was clear that the very serious problems of a kind or degree differing from those existing when that treaty was drawn up had come to characterise inter-country adoption. Controversy had arisen not only because of some of the serious abuses of the system, but also because of an increasingly prominent view that it's in children's best interests to remain within their own local communities and cultures. The Inter-Country Adoption Convention aims to establish safeguards to ensure that inter-country adoptions take place in the child's best interests and with respect for his or her fundamental rights as recognised under international law. For example, states must ensure the child is adoptable, ensure that freely given informed consent has been obtained from all relevant parties, preserve information about the child and his or her parents, match the child with a suitable family, and impose additional safeguards where needed. Once an adoption is certified under the Inter-Country Adoption Convention, it must be recognised by operation of law in other contracting states. The desirability of the Convention is highlighted by stories of children removed from Haiti after the earthquake and from Aceh after the tsunami. One of the byproducts of the Inter-Country Adoption Convention, which I will discuss more later, is the rise of international surrogacy arrangements. This is partially because the safeguards imposed under the Inter-Country Adoption Convention mean that international adoption is now quite difficult. By the time the checks have been carried out and the requirements met, the child is often a toddler or older. As a result, those who want a baby have begun to look at other available means of making this happen, with the technological advances in artificial insemination and similar procedures now providing an avenue to fulfil that desire. The third convention is the Protection Convention. The Protection Convention revises an earlier convention and seeks to rectify issues that had arisen in the application of the earlier convention and to take into account the Abduction Convention and the Convention on the Rights of the Child. The Protection Convention's preamble explicitly refers to the Convention on the Rights of the Child, and several of its terms implement specific provisions. For example, recognition in Article 23(2)b of the importance of the child having the opportunity to be heard. The Protection Convention applies to a wide range of legal proceedings concerning children, including measures dealing with parental responsibility, custody and access, guardianship, including the child's property, and foster or institutional care. The Protection Convention governs jurisdiction to take measures directed to the protection of the personal property of the child. It also covers, importantly, the law authorities exercising jurisdiction will apply, and questions of applicable law concerning parental responsibility for a child where there's been no specific intervention by authorities such as a court order. Provision is made for the recognition and enforcement of measures between contracting states, in other words, court orders relating to children, and for administrative cooperation between contracting states to ensure the proper operation of the Convention. Following Australia's ratification and implementation of the Protection Convention in 2003, the limited number of contracting states meant that the Convention was largely dormant for us until around 2012, when all of the EU member states finally ratified it all at once. We're now getting increasing numbers of cases involving the Protection Convention in circumstances where there's been little experience with its operation. Important guidance, however, can be found in the jurisprudence relating to the EU's Brussels 2 bis regulation, which determines jurisdiction in family law matters between EU member states, with the exception of Denmark, and which was closely modelled on the Protection Convention and has been in place since 2003. From the Australian perspective, we've always had a very wide jurisdiction in relation to children and have been able to make orders even if a child is habitually resident in another country, as long as that child is an Australian citizen. In many cases now, that jurisdiction will be curtailed by the Protection Convention. The Child Protection Convention has the potential to become an extremely important convention. For example, its capacity to supplement or augment the Abduction Convention has been highlighted. The fourth convention is the Child Support Convention. Essentially, this convention is a system of administrative cooperation for processing international child support applications designed to handle large volumes of cases. In order to facilitate the conduct of cases brought under the Child Support Convention, the Hague Conference developed an innovative system of electronic country profiles and a system for international electronic communication and case management. These systems, which allow information to be changed from one language into another with a single computer click, should eliminate much of the need for foreign language translation in child support cases. What has often been called the reverse side of the abduction, of child abduction, is international relocation. International relocation and international parental abduction are the obverse of each other. Both involve the cross-border movement of a child with one of his or her parents, in one case permitted by the court, the other, or the parent, the other not. The disputes in regard to each type of case take place on opposite ends, legally and practically. Relocation disputes pertain to applications for permission to remove the child from one country to another and are governed entirely by the domestic law of the country in which the child is originally resident. Child abduction cases involve applications for a court order for a return after removal has already taken place. In its report on relocation, released in May 2006, Australia's Family Law Council recommended that a specific provision be inserted into the Family Law Act, which would in effect act as a guideline for the determination of relocation disputes to augment the best interests, primary and additional considerations already found in our Act. To date, this recommendation has not been implemented. So in general, when Australian courts consider a relocation application, a discretionary best interest test applies. Some other jurisdictions have presumptions one way or another. In my own view, any attempt to impose a presumption in Australia would be unfortunate. I accept the criticism raised by many academics that there is no certainties for parties who find themselves in this position. But relocation cases between two good parents are some of the most difficult decisions to make, and I personally would not want to see the discretion to arrive at the best possible arrangements for the child in each individual case fettered in any way by legal presumptions and the onus of proof. But this is my personal view. Into the future, the Protection Convention will be of particular assistance in international relocation cases, as it will help, for example, Australian courts to obtain what we call mirror orders or recognition of orders in other contracting states. That can be done by orders of an Australian court being recognised and declared enforceable, and that will be one of the, I think, most significant elements of the Protection Convention. I want now to touch on one of the jurisprudential clashes, if you like, in international family law, and that is the decline in influence of common law jurisprudence and the rise of the European Union. The European Court of Human Rights, based in Strasbourg, rules on individual or state applications alleging violations of civil and political rights set out in the European Convention on Human Rights. I've already indicated that the statute Brussels 2 bis, which applies between European countries, deals with a lot of matters, including jurisdiction, in relation to children's cases between the EU members. The Court of Justice of the European Union, on the other hand, is based in Luxembourg and is the highest court in the EU as far as matters of EU law are concerned. Accordingly, it has jurisdiction over, for example, Brussels 2 bis. Neither court's decisions have direct application in Australia. Nonetheless, we are not entirely immune from their reach, and certainly our colleagues in EU countries are directly affected. The rise in prominence of civil law jurisdictions and concomitantly emerging tensions between decisions of common law jurisdictions and those invoking the provisions of European instruments can be sharply observed in the decision of the European Court of Human Rights in Neulinger and Schuruck in Switzerland. The case involved a return application issued under the Abduction Convention, whereby the party ordered to return subsequently issued proceedings in the European Court of Human Rights, invoking Article 8 of the European Convention on Human Rights. This provides, 1, everyone has the right to respect for his private and family life, his home and his correspondence. 2, there shall be no interference by a public authority with the exercise of this right, except as is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. I've never had anyone explain to me in any meaningful way what all of that really means. Neulinger involved the wrongful removal of a child from Israel to Switzerland by his mother, a Swiss-Belgian national, in 2005. The father initiated proceedings for return under the Abduction Convention, in quite an orthodox manner. The Swiss Federal Court reversed the decisions of the district and appellate cantonal courts, which had upheld a grave risk defence, and they ordered the child's return to Israel by the end of September 2007. The mother failed to return the child, but the order was never enforced because the mother initiated proceedings in the European Court of Human Rights, challenging the order on the basis of Article 8. In June 2010, so we're now 5 years from the original abduction, the Grand Chamber determined that Switzerland would be in violation of Article 8 if the return order were enforced. And so finding, the Grand Chamber held by a 16-1 majority that although the return order complied with the Abduction Convention, the court was not convinced that it would be in the child's best interests for the child to be returned to Israel, and furthermore held that the mother would sustain a disproportionate interference with her right for respect to family life if she were forced to return to Israel. Thus, the European Court of Human Rights determined that the child should not be returned. Unsurprisingly, the decision was received with some dismay by the international family law community. There was concern that the court's emphasis on the need for judges to conduct an in-depth examination of the entire family situation, as they said, and assess the child's best interest in every case, could be perceived as encouraging national courts to look into the merits of the case in an Abduction Convention application. The troubling trend continued in the subsequent cases of Raban in Romania, Sneerson, Campanella in Italy, and the initial decision in X and Latvia. However, the Grand Chamber's decision in X and Latvia arguably responds, at least to some of the criticisms of the Neulinger approach. You'll see in a moment I have an interest in X and Latvia because although it doesn't appear to have any connection with Australia whatsoever, it has a very significant connection with Australia. In X and Latvia, the child was taken from Australia, her place of habitual residence, to Latvia by her mother. The father commenced Hague proceedings under the Abduction Convention, and the Latvian court made a return order. The mother appealed. On appeal, the mother asserted the child was well settled in Latvia and submitted a psychologist's report stating the child should not be separated from her mother and the child would suffer psychological harm should separation occur. The mother also said she lacked funds to return to Australia. The appeal was dismissed. Proceedings were brought in the European Court of Human Rights, contending that the mother's right to respect for family life would be violated by the return order. There was one significant difference between this and the Neulinger decision. Whilst Neulinger finally came to the Grand Chamber the First Chamber after 5 years, this case was fairly speedily resolved. X and Latvia was first heard in 2011 by the third section, which held by a majority of 5 votes to 2 that there had been a violation of Article 8. The case was then referred to the Grand Chamber, which delivered judgment in November 2013. There was no dispute about whether the return order amounted to interference with the mother's right to respect for her family life as protected by Article 8. Accordingly, what remained to be determined was whether the interference was in accordance with the law, pursued one or more legitimate aims as defined in that paragraph, and was necessary in a democratic society to achieve them. In the court's view, the decisive issue was whether a fair balance had been struck between the competing interests at play, with due account being taken of the fact that the best interests of the child must be of primary consideration, and the objectives of prevention and immediate return correspond to a specific conception of the best interests of the child. So far, so good. But the majority of the court found, in a decision that split the judges 9-8, ultimately that the first instance decision of the Chamber should be upheld and the child had been wrongly ordered to be returned. They said, in the context of an application for return made under the Hague Convention, which is distinct from custody proceedings, the concept of the best interest of the child must be evaluated in the light of the exceptions provided for by the Hague Convention, which concern the passage of time, Article 12, the conditions of application of the Convention, Article 13A, and the existence of a grave risk, Article 13B, in compliance with the fundamental principles of the requesting state relating to the protection of human rights and fundamental freedoms, Article 20. The court held the exceptions in the Abduction Convention must be strictly interpreted, but before returning a child, the relevant state must give due consideration to any arguably alleged grave risks and provide reasons specifically detailing why the decision was made as it was in the circumstances. The court stated that the grave risk must be interpreted in the light of Article 8 of the European Convention on Human Rights and therefore includes, quote, all situations which go beyond what a child might reasonably bear. However, despite the decision in Ex in Latvia, it's largely regarded as having, to a fair degree at least, ameliorated the view that the position that had been taken in Neulinger, and due accord was given to the Abduction Convention. The interesting part of Ex in Latvia was that, for me at least, was that when the order was first made by the Latvian court for return, the mother didn't actually hand the child over to the father. However, the father went to Latvia, managed to locate the mother and take the child and return with the child to Australia. The mother followed the father to Australia and proceedings occurred in Australia, the country of habitual residence, in relation to the child and were concluded in the father's favour long before the Grand Chamber made its decision in Ex in Latvia. So there were sort of parallel proceedings which were to some degree like ships passing in the night. What are some of the current challenges then in family law? The first I want to mention is international commercial surrogacy. International surrogacy arrangements are growing at a rapid pace. The Hague Permanent Bureau's 2012 preliminary report on the issues arising from international surrogacy arrangements analysed data from 5 agencies specialising in international surrogacy and found that the market had grown by 1,000% between 2006 and 2010. The Permanent Bureau attributes this to a convergence of scientific, demographic, legal and social developments, including artificial insemination and IVF, an increase in infertility in certain states, and an increasing acceptance in some states of parenting within alternative family forms. The preliminary report also mentioned, as I alluded to above, that the demand for surrogacy services may be related to changes in the field of inter-country adoption. As compared with traditional surrogacy, cross-border surrogacy usually involves gestational surrogacy, which is where the surrogate mother carries a child that she is not genetically related to, created from eggs and sperm deriving from either the intended parents or donors. Legal issues arising from cross-border gestational surrogacy arrangements include the parentage of the child, citizenship, immigration and contractual issues. Conflicting laws between jurisdictions on parentage, citizenship and surrogacy mean that a child in some circumstances can end up with no legal parents or nationality. In Australia, most states allow altruistic surrogacy, and state-based regimes provide for the transfer of legal parentage in such cases through the equivalent of parenting orders. With the exception of the Northern Territory, which doesn't regulate surrogacy at all, commercial surrogacy arrangements in Australia are illegal. In 3 places, the Australian Capital Territory, New South Wales and Queensland, those states have taken the additional step of making it a criminal offence for residents of those states to enter into a commercial surrogacy agreement internationally as well as in Australia. Nevertheless, couples from those jurisdictions have sought international surrogacy services, and in turn this has resulted in proceedings before the family court for declarations of parentage and parenting orders in respect of children born as a result of cross-border commercial surrogacy arrangements, which are illegal in Australia. The arrangements are popular, and many countries have seen the growth of an industry around surrogacy. A quick internet search reveals advertisements for eggs and sperm and surrogacy arrangements in various countries. In Denmark, there's an industry around the provision of so-called Viking sperm. In 2011, the women's magazine Marie Claire contained an article on the phenomenon of women seeking out Viking sperm. And if I were showing you a PowerPoint at this point, I'd be showing you a little baby with a sort of nappy and a little knitted Viking cap with a caption that says, "Congratulations, it's a Viking." Australia makes up 25% of the international surrogacy market. In our region, the popular countries for surrogacy arrangements have traditionally been India and Thailand. However, 2 significant events have occurred in recent years to change this landscape: the baby gammy and Indian twins cases. The first involved commissioning parents, one of whom was a convicted child sex offender, of twins born to a Thai surrogate, who took only one of the twins home with them to Australia. The second child, known as Gammy, was born with Down syndrome and a hole in his heart. Gammy had been diagnosed with Down syndrome in utero, and the commissioning parents had tried to prevail upon the surrogate mother to abort the affected fetus. She refused. After the twins were born, the commissioning parents took the healthy baby to Australia and left Gammy in the care of the surrogate mother. This case came to the attention of the Thai authorities and press, and there was outrage in both Australia and Thailand. In the Indian twins case, the Indian surrogate was found to be carrying male-female twins, but the contract with the commissioning Australian parents only required the Australian couple to take one child. The couple could not be persuaded to take the other, their decision being made on the basis of gender. They already had one child of one gender and they wanted another of another gender. The surrogate mother, in this case, was not in a position to keep the child, and the child was taken by someone unknown to the Australian authorities. When this case became known to the public, again, there was media and public outrage. I have a particular interest in this case because I turned out to be the sort of whistleblower about this case. As a result of these high-profile cases, in February 2015, the Thai National Legislative Assembly passed laws banning all foreign and same-sex couples from seeking surrogacy services in their country. The laws also ban advertising and promotion of surrogacy services and shut down agencies and unregistered clinics. In direct response to the twins case, India has tightened its visa requirements and is not accepting any new surrogacy visa applications from Australian citizens. The ban does not apply to citizens from other countries. As a result of that, the industry has now moved to Nepal, although it's been affected by the recent earthquakes in Nepal, to Mexico and to Cambodia. So the clinics are still operating, but further afield. One of my major concerns about this form of surrogacy is children's human rights. Article 7 of the Convention on the Rights of the Child provides that children have a right to know their parents. Increasingly, international commercial surrogacy arrangements involve the use of anonymous donor eggs by commissioning parents, making it impossible for children born of such arrangements to ever trace their genetic parentage. We know that adopted children and children born through sperm donation are often keenly interested in their origins. Children born through surrogacy too have a right to know their heritage, and those rights, in my view, are being ignored in circumstances where the identity of the egg donor cannot be ascertained. In my view, it's negligent not to regulate surrogacy to ensure that children's rights are protected. My concerns are echoed by the Permanent Bureau in their 2014 study of legal parentage and the issues arising from international surrogacy arrangements. An international coordinated regulatory response to commercial surrogacy is required, ideally culminating in an international convention similar to the Inter-Country Adoption Convention. In furtherance of that, the Hague Conference has had a parentage and surrogacy program on foot for a number of years. In 2015, the Hague Conference Council on General Affairs and Policy decided to convene an experts group to explore the feasibility of drawing up a multilateral instrument on international surrogacy arrangements. The experts group are due to meet early 2016 and report to the 2016 Council meeting. Although these developments on the international stage are encouraging, the development of a multilateral instrument takes many years, often up to a decade. In the interim, it's up to individual states to make arrangements that are consistent with the best interests of children. Turning to the intersection between international family law and refugee law, it's somewhat trite, but nonetheless necessary to note that the number of people currently fleeing their home countries is extraordinary. In Australia, debates about asylum seekers and refugees have intensified since the crisis hit Europe. We must all understand that it's been unfolding for many years. By the end of 2014, 59.5 million individuals were forcibly displaced worldwide as a result of persecution, conflict, generalised violence or human rights violations. To put things in perspective, that's roughly the size of the population of Italy or the United Kingdom. That was an increase of 8.3 million persons from 2013, and the highest annual increase in a single year on record. Children below the age of 18 made up 51% of the refugee population in 2014, up 10% since 2009, and the highest figure in over a decade. And as people traverse the globe in search of safety, children are, of course, particularly vulnerable. Of the Hague Children's Conventions, the only one to explicitly mention refugee children is the Protection Convention in Article 6. I'm not aware of any relevant case law in Article 6 as of yet, but it will be very interesting to see how things develop. Jurisprudence coming out of the European Court of Human Rights is likely to be particularly interesting, since the EU is facing such a significant influx of asylum seekers, and the Court has previously recognised the importance of the Convention on the Rights of the Child. In the context of asylum seekers and refugee children, the Convention on the Rights of the Child could be extremely powerful. As the European Court of Human Rights said in Saarhen in Germany, the Convention on the Rights of the Child spells out the basic human rights that children everywhere, without discrimination, have: the right to survival, to develop to the fullest, to protection from harmful influences, abuse and exploitation, and to participate fully in family, cultural and social life. States parties have to ensure a child is not separated from his or her parents against their will unless such separation is necessary for the best interests of the child, and to respect the rights of a child who is separated from one or both parents, to maintain personal relations and direct contact with both parents on a regular basis, except if it's contrary to their wishes. This is in addition to the particular rights of refugee children under Article 22 of the United Nations Convention on the Rights of the Child. The other Hague Children's Conventions, other than the Child Support Convention, are also relevant to refugee children, although in more peripheral ways. In 1994, a special commission convened to study the specific questions concerning the application of the Inter-Country Adoption Convention to refugee and other internationally displaced children, adopted a recommendation which set out several principles for contracting states to take into account in applying with respect to these exceptionally vulnerable children. The recommendation is consistent with the UNHCR's policy on the adoption of refugee children. Of course, such policies can be difficult to oversee on the ground in disaster zones. An application for asylum can be relevant to the exceptions to return in Article 13 of the Abduction Convention. For example, in the Canadian case of AMRI and KER, the Court of Appeal of Ontario found that when a child has been granted refugee status, a rebuttable presumption arises that there's a risk of persecution if the child is to be returned, and thus a risk of harm. The court said that this must be taken into account in the analysis of the Article 13b grave risk exception to return. The Court of Appeal's conclusion was consistent with UK jurisprudence as well. In Re S, Children Abduction Asylum Appeal, Lord Justice Laws said, having regard to the rule as to the paramountcy of a child's interest arising under Section 1 of the Children Act 1989, I would respectfully suppose that a family court judge would at the least pay very careful attention to any credible suggestion that a child might be persecuted if he were returned to his country of origin or habitual residence before making any order that such a return should be effected. In the United States, the Court of Appeals for the Fifth Circuit found in the 2014 case of Sanchez and RGL ex Hernandez that while a grant of asylum is relevant to the question of whether an exception to return ought to apply, the finding under refugee law that the children had a well-founded fear of persecution did not substitute for a finding under Article 13b. The Court also noted that the evidentiary burdens under the Abduction Convention, as implemented in the United States, are stricter than those in asylum proceedings. The circumstances surrounding the cases discussed above have not as yet arisen in Australia, so it remains to be seen how an application for asylum would affect decision-making under the Abduction Convention in our jurisdiction. This is not to say that family law has not had a part to play, and I'll round off this section by briefly discussing the 2003 case of B&B and the Minister for Immigration and Multicultural and Indigenous Affairs. Under the Migration Act 1958, if an asylum seeker arrives in Australia without a valid visa, they must be held in immigration detention until they're granted a visa or removed from Australia. This includes children, though children should only be detained as a measure of last resort. In 2002, two boys aged 12 and 14 made application through their mother as next friend to the family court for orders that the Minister for Immigration released them from immigration detention. The children argued that continuing detention was harmful to their welfare. The trial judge held that the family court had no jurisdiction to make orders in respect of children held in immigration detention and dismissed the application. There was an appeal to the full court which allowed the appeal. I won't go into great detail about the full court's reasons, as complex questions were considered, including intricacies that are specific to the Australian legal system. However, in June 2003, the full court found the trial judge had wrongly decided the court did not have a welfare jurisdiction in respect of children in detention, and said that the court had jurisdiction to order the children be released from immigration detention. The appeal was allowed and the matter was remitted for rehearing. Unfortunately, that didn't last long. The Minister appealed to the High Court of Australia, which is Australia's final court of appeal, where the court unanimously allowed the appeal in 3 separate judgments. In short, the question of whether the family court has jurisdiction in respect of children in Australian immigration detention fell to be decided in reference to the Family Law Act and its relationship with the Migration Act. To date at least, the High Court has made it clear that children who are unauthorised arrivals into Australia, including refugees and asylum seekers, do not fall within the jurisdiction of the Family Court. I just want to touch on Australia's role in our region. In the past 40 years, there have been considerable and significant developments in the Asia-Pacific region, and Australia has been seen as having a leadership role. This is due to many factors. We have a family law system and a family court system that is the envy of many states, at least it has been up until now. Our use of family consultants is highly regarded, and innovative practices are seen as best practice, and the thus far well-funded wider family law system is seen as something many countries would like to emulate if they had the resources. Australia has always been a strong supporter of international treaties, and we've been an early adopter of many. Contributions by Australians to the development of the Hague Children's Conventions mean that we're well regarded by the Permanent Bureau, and our advice is sought in our region. A recent example of Australia's regional involvement is our work with Japan. We worked particularly closely with Japan, as did other countries, in the lead up to their ratification of the Abduction Convention in April 2014, and since then we've been working together with the aim of providing co-mediation in abduction cases, mindful of the socio-legal differences that characterise parenting cases in our respective countries. In September 2015, 13 Australian participants, social scientists, lawyers who are trained mediators, and one of the judges of the family court went to Japan, where they joined similarly trained Japanese professionals for intensive training in co-mediation techniques, both for electronic and face-to-face mediation. Some of the participants were also trained in the use of an electronic supervised access module, generously developed by the Japanese Ministry of Foreign Affairs, though this is still in the developmental stage. The idea of supervised electronic access between the child and the left-behind parent is exciting. It will, of course, involve complete control by a supervisor and will hopefully also have the capacity to record the session. We're discussing how to include an interactive game or activity for the left-behind parent and the child to share. We envisage that both the co-mediation training and the electronic access models could be a helpful model for other countries to consider in the future. Reciprocity is utterly essential to the success of the Hague Children's Conventions. There's no international body to enforce compliance or resolve disputes. Accordingly, reciprocity is achieved through active collaboration of contracting states' governments, in addition to frequent meetings of member states in which they consider how to improve the operation of the of the convention. Communications between central authorities and judges has proven essential to the convention's success. As Professor Eston notes, this cooperative approach is unique within the universe of international law and has led us to a new model of international law, a different type of foreign relations carried on by judges and bureaucrats as well as diplomats. The Hague Conference has consistently endeavoured to facilitate innovative systems and practices that enable sound implementation and operation of the Hague Children's Conventions. A very significant example of this is the International Hague Network of Judges, and some of my colleagues from the meeting we've had today here tonight. The meeting we had was of the International Hague Network of Judges. The concept of this was first suggested at the 1998 de Ruenberg Seminar for Judges on the International Protection of Children by now retired Right Honourable Lord Justice Matthew Thorpe, then a Judge of Appeal for England and Wales. The idea involved relevant authorities in different jurisdictions designating one or more of the members of the Judiciary to act as a conduit for communications and liaison with the central authorities, with other judges within their jurisdiction, and with judges in other contracting states in respect, at least initially, of issues relevant to the Abduction Convention. The Hague Network of Judges currently includes more than 101 judges representing 82 countries on all continents. The role of a member of the network is to act as a link between his or her colleagues at the domestic level and other members of the network at the international level. There are two main communication functions exercised by members of the network. The first is of a general nature, entailing the sharing of general information from the network or the permanent bureau with his or her colleagues in the jurisdiction and vice versa. The second consists of direct judicial communications with regard to specific cases, not the merits of those cases, but with the objective of such communications being to address any lack of information that competent judge has about the situation and legal implications in the child's state of habitual residence. In this context, members of the network may be involved in facilitating arrangements for the prompt and safe return of the child, including the establishment of urgent and/or provisional measures of protection and the provision of information about custody or access issues or possible measures for addressing family violence or abuse allegations. It can include, for example, inquiries about the status of a re-entry visa or potential criminal proceedings for breaching orders in the other jurisdiction. My colleague Justice Bennett describes this as facilitating a soft landing for the children who are being returned. In Australia, in the absence of any legislative imprimatur, we take the view that there must be complete transparency and procedural fairness where direct judicial communication takes place. We only embark on contacting a network judge in another jurisdiction with the consent of all parties who are fully informed about the nature and extent of the inquiry being made. Typically, a trial judge who's obtained consent would contact the family court network judge, who would then communicate with the network judge in the other jurisdiction. The communication is by email, and the network judges usually reply promptly. The response and the original emails are provided to the trial judge and the parties and become an exhibit in the case. Because of the conferences and meetings the network judges attend, they are almost all known to each other, and the personal relationships are a crucial part of the success of the Hague Network of Judges. While initially conceived of as a means of cooperation in respect of the Abduction Convention, it is now recognised that there is a broad range of international instruments, both regional and multilateral, in relation to which direct judicial communications can play a role. As you can see from the broad range of topics traversed in the paper, international family law is a vibrant and complex area of law. The innovations of the Hague Conference have created a fascinatingly rich tapestry in which judges and national and international bureaucrats work together for the betterment of families across the world. There are challenges, old and new, to be faced going forward in the 21st century. But if the history we have made together is anything to go by, it will be a very interesting future indeed. Thank you very much.
Thank you very much, Chief Justice Bryant, for a most illuminating lecture. I think we're all very privileged to have some contact with your personal insights in this very important area. The Chief Justice has graciously agreed to take a couple of questions. If anyone in this room has a question, may I ask you to please keep your question short and please identify yourself for the benefit of the rest of the audience. Thank you.
Chief Justice, my name is Robert Ashton. I'm a family practitioner in Hong Kong. Could I just ask this question? Does the Hague Network of Judges extend to jurisdictions which are not signatories to the Hague Convention on Child Abduction?
It does. It does. One of the things that the Permanent Bureau encourages is for countries who are still considering whether they'll they ratify the conventions to nevertheless appoint network judges, so that there are a number of jurisdictions that have done so. And that facilitates the same sort of international cooperation, even though you may be looking at questions of forum outside a convention.
Thank you.
Perhaps I will exercise my privilege as a chair to ask a question of the Chief Justice. Chief Justice, I perfectly agree with you that the development of international law in any area, whether family law or commercial law for that matter, is always going to be challenging, mainly because international law is not prescriptive, isn't it? It's got to inspire in order that domestic legislatures would wish to embrace whatever has been set out in international conventions. Would you agree with me, though, that family lawyers as a group, as compared with commercial lawyers, are in fact better placed to develop these inspiring family law international conventions? Because we are very used to the idea of family law having to inspire people to behave better.
I'd like to think that was the case. And I think that there are, I'm aware of direct judicial communications being involved in cross-border insolvency cases, although I don't think it's anywhere nearly as developed as the Hague Network of Judges is, and perhaps that's exactly the example of what you're speaking of. That's been around for a long time, but I think what's really developed has been the network of judges, and I think that demonstrates exactly what happens when you have different jurisdictions, civil law jurisdictions, common law jurisdictions, some cases jurisdictions where there might be Sharia law countries and so forth, where there's a commonality of interest about the best interests of children, and that I think does make a difference to both the ability to connect with the other countries and the other judges, and thus the ability to develop the law and the effective measures more than other jurisdictions.
I wonder, a small woman from the University of Aberdeen, I wonder if Chief Justice might comment a bit on her work in the expert group on the grave risk of harm without disclosing any confidential information, but it would be of interest, I think, to know how that work is progressing.
I have to say it's progressing slowly. It's a really difficult task, actually. I think we're finding it quite challenging. But as I said, I've got at least three members, I think, of the working group here this evening. And part of what we're doing, I can't tell you much more than that, part of what we're doing in this meeting, we've got some more tomorrow morning, is to discuss some of the, it's a guide to good practice, so what we're trying to look at is good practices, and it's challenging partly because we do have different ways of looking at things in common law and civil law jurisdictions, and the Brussels 2 bis has some provisions which have to be applied by EU countries which are not applicable in common law countries. All of this has to be taken into account. But good practices transcend really all of those things, I think. So I'm sorry I can't be more specific, but just watch this space, I guess.
Perhaps the Chief Justice might comment a little on the challenges faced by the Hague Conference's Malta process.
I'm probably not the best person to talk about that, Selma, because I haven't really had much to do with the Malta processes. You probably know more about it than I do, or just as someone else might want to comment on that. But because I've not been to one of those fora, but in broad terms, I think that the Malta conferences relate to really largely Islamic countries who haven't signed up to the convention. So all I would say about them is that the fact that there are conferences of that kind in countries which feel that, at least at this stage, they're not in a position to ratify the conventions, nevertheless have an interest in doing what they can to foster international cooperation about children.
I would guess that that's also progressing fairly slowly.
Yes.
Moving ahead,
yes,
but fairly slowly. Would anyone care to comment on it? Yeah, actually, I've attended.
Justice Bennett, maybe she was
Justice
at the last
Bennett,
one,
yes, please.
I was privileged to go to the last one because the Chief Justice sent me, but the last one was 7 years ago, and they were intended to be at least every 3 or 4 years. So that is one of the challenges. But Malta has agreed very generously to host another, and that represents not only organisational resources devoted, but considerable financial resources. I think one of the things that the Chief Justice and I appreciate from the meetings that we've had now for a day and a half is something that Lord Justice Thorpe said, and it was in effect, the easy things have been done. What we're dealing now with are the difficult things, and nothing could be truer than the 13(1)(b). I think they left the hardest till last, and the Chief Justice has got that. In terms of the Malta process, everybody is very enthusiastic about it, but it's one of the hard things. But it's one of the things we want to do, and it's very rewarding, and I think under the Chief's leadership, Australia's going to back the next conference, which will be in May next year, and probably attend this time.
Thank you very much, Justice Bennett. Are there any other questions? I'd like to slide in one more question. You made a very interesting observation, Chief Justice, about the challenges posed by commercial surrogacy. And I'd just like to hear your thoughts. I remember you said that it may be better for us to regulate it in order to be able to control it. Would you go so far as to think that regulating it means that we must go some way towards accepting its legality?
I think that's probably inevitable. I mean, there certainly may be ways of regulating it short of that. Well, I suppose any regulation assumes some degree of acceptance. One of my major concerns is about the rights of the child, and it just seems to me that Australia as a country could, for example, impose some limits on the ability of parties to bring a child back into the country. They could refuse to allow the child to come into the country if the parents hadn't complied with certain requirements. So you could require that there was the child knew who the mother was, knew who the surrogate mother was, various things like that. Now, if those things were not complied with, and I've noticed, then you could perhaps enforce it. And I know that's difficult, but I still think there are potentially ways around that. I was thinking the other day, we make the Minister of Immigration the guardian of unaccompanied minors and refugees and asylum seekers, and you could, for example, have the Minister for Immigration being responsible for a child who was entitled to citizenship who a parent, like the twins case, didn't want to bring back to Australia. So the Minister could bring the child back to Australia and the child could at least be adopted in Australia. I mean, there are things that you can do, I think, if you're thoughtful about them, but you've got to have some interest. But there's likely to be, I've been agitating as much as I can in Australia for there to be an inquiry into international surrogacy, if not domestic surrogacy, and I'm hopeful that we'll have that fairly soon, because I think that Australia's got a responsibility. I think we make up 25% of the market, and it's just, I think it's not really right that we, some people, not everyone by any means at all, but some of our citizens exploit things. Interestingly enough, I mentioned the baby gammy case. My colleague, the Chief Judge of the Family Court of Western Australia, is at this very moment hearing the gammy case, because the father and the contracting parents went back to Western Australia where they live. As I said, he's got a criminal record for paedophilia, and the mother, the Thai mother, is now applying for custody of that child. So pretty interesting case going on at the moment, and I'm sure it'll hit the headlines, I would have thought, when the results handed down.
Thank you. I'm very conscious of the time, so if there are no other questions, I'll ask us all to put our hands together and thank you very much, Chief Justice Bryant, for an excellent Hochelaga lecture.